We will discuss in this very huge, as far as the number of speakers is concerned, very huge session, the reaction of the European Union on COVID. And I will introduce the different speakers one by one. Once it's their turn, I have to ask them to please keep within 10 minutes, because otherwise we can't go through, because we have a limited time, unfortunately. But it should be possible, isn't it? Pablo, do you hear me now?
I hear you. Do you hear me?
Very good. Very good.
Okay.
So, the first speaker will be Juan-Pablo Landa. He is from the...
from Spain. From Spain.
From Spain, yeah. From, I look for the university. From the Basque University. And he will speak a long, long title. I read it for you. Some ideas about the more useful methodological approach to the question of what kind of role the labor law can play in a human-centered, we heard again this already this morning, this human-centered approach in the human-centered recovery past COVID. Pablo, the floor is yours, and please, within 10 minutes.
Well, the first thing I want to say is I'm very pleased to be with you in this meeting, in this conference. Well, thanks to the online connection that works very well. But at the same time, I try to do my best. I had some papers, some written, but 10 minutes is very, very few time. I'll try to do my best. I wanted to say two things, or to speak a little about two things. One is the main question of our seminar is to answer about what labor law be like if its actual object blurs in the future, because I'm thinking in all this digital revolution and what this crisis like post-COVID or a war crisis as we are living at the moment in Europe can produce. So, and the effects that they can have in the functioning of our labor law system. But in any case, the second thing, and probably the best of all, the central object of my paper is to look for answers about the future about labor law, of course, but what for me is very, very important to speak about the, I have a critical view about the risk that for labor law researching can produce if you follow and adopt alternatives, or as some people say, utopian methodologies for improving labor relations in the future, forgetting our classical historical methodology founded on the ideas of political democracy, free markets, and human rights. I say that because, I say in 2 minutes something about this, but to my view, I have a fear that is about the possibility or not, about it will be possible to withstand with the liberal ideas of the 18th century in face of transforming force of climate change and the changes that the technological revolution and globalization will produce on the industrial relations system. In order to respond to this question methodologically, we must not be swept away by current philosophies or constructivist theories that are based on a relativization of history, as for example the meta-art. and may lead us to a new dogmatism directed towards theory aside facts, or recreating reality as the final result of a construction of social construct that is accepted by tradition or by seeking some supposed social happiness. For this purpose, it's not necessary to project a new idealistic brave world, forgetting our own history. An example, the idea of social happiness that is very recognized in some writings was already used in the USA Declaration of Independence. So one thing is to say good things, and another thing is to be, well, what I consider near to the reality. To my view, the way to reveal the central role of labor law in a future human-centered economic system must follow the approach from the traditional methodology of historical research, with research upon verifiable facts and theories that are checked and criticized. And for me, we must maintain this kind of thinking, of course, of methodological research instruments. Well, from my point of view, our society is not in such a desperate situation as to call into question our entire history. The 28th crisis show, among other things, that the economy's occurrences about the future were not right in general. It shows us that we need economists working with a moral sense too. And the macroeconomic response to the COVID crisis has been quite different. And also from an ethics perspective, I subscribe this special idea that we must work also with an ethics perspective of the results of our research. But in any case, this crisis doesn't justify the necessity for human beings or render questionable the rational economic man as theorized by Adam Smith. That is, in the end, is something that is necessary to maintain, because we can't think in a political model of illiberal governance or ruled by interventionist states more and more authoritarians. To my view, that could be the consequence if we finish by forgetting our history. In any case, as the crisis of COVID indicates, rather than a revolution, a correction of the functioning of our productive economic model is occurring, but without replacing our capitalist economic model. The answer given by Europe or the USA is very similar to that made by Franklin Delano Roosevelt with the New Deal in 1933. Massive public programs of economic relaunch and public debt. Well, the important thing that occurred during the 2019 has been the opportunity to check out a life without economic growth, a central issue for a green economy. We can even evaluate the economic cost of a suspended life with production limited to satisfy the basic needs of humanity in pandemic times, or with dynamics of economic growth very small. But we cannot imagine a post-growth era if we were to conceive of how the world worked when there was no economic growth. So these ideas of post-growth, post-work, to me is we need to recuperate the sense of reality. We could go on discussion about post-growth while our political leaders and international institutions design target plans for economic growth, salary raises, employment and skills growth, education and health system improvement. All this entails that we keep on growing, rationally, of course, in a sustainable and inclusive manner, evaluating and checking for any deviation. Labor law, as the law for the labor market, will have to widen these objectives and open up its field of intervention to new questions of economic, sociological, psychological nature, and so on, with a view to being more efficient in its proposals of legal regulation, offering to every new juridical form of exchange between persons a legal solution adapted to that relationships. I'm thinking especially in the caregivers problem or digital workers in general. So the fourth technological and digital revolution could let us get rid of criteria such as productivity and could free the immense majority from the need to work. It will also reach the universal human happiness as is being suggested, perhaps, but this would not mean, for me, the end of work. Labor law has enough legal tools to keep favoring its function of balancing the interest and protection of workers. Old and young, conveniently adapted to their announced changes, it can continue to perform its traditional role of governance of the labor market. Thank you. I think I almost in time, Professor Weiss, excuse me. I have made some improvisations, but well.
Thank you very much, Pablo, for keeping the time and for giving us at the beginning of this debate such an interesting methodological approach. We will come back to it in this discussion, I'm sure. Now we come to our second paper, and this is a paper which was written by two authors, by Antonio Aloisi, who is, as you know, at the University in Madrid, in Spain, another Spaniard, huh? Yeah, but coming now from Spain. And the second author of this paper is Silvia Rainone, and she belongs to everywhere, which means she is at the European Trade Union Institute, she is at the University of Tilburg, and she is at the Catholic University of Leuven. Well, are you presenting alone? Yeah, okay. Okay. Well, the paper will be on the EU path towards the social market economy through the pillar of social rights and the action plan and the big question which is asked, does it make a difference? Go ahead and tell us.
Thank you very much, Professor Weiss, and thank you also to Professor Philippe for discussing today. Is it working now? I think so. So again, and thank you also to the guests and to the attendants. Now, the title and the goal of this paper, we started working together with Silvia last year, and the idea was to basically test and assess and evaluate both the European Pillar of Social Rights and the action plan. This is the first anniversary of the action plan. The idea was to understand to what extent these two paramount initiatives and exercise of improvement in terms of social policies were keeping up with their expectations. And if we consider all the other measures that have been adopted at the European Union level, we must agree that there is something very ambitious going on because of the current crisis, because of the aftermath and the consequences from an economic and legal perspective brought about by the pandemic. There was an interesting blog post published on Social Europe claiming that if there is sufficient urgency and political will, what were once firm limits no longer seem quite so rigid. So if there is willingness, things may and must change. Of course, we are kind of experiencing a similar type of very bold action in other fields beyond the social field. Think of the large return of the state, taking measures to cover self-employed workers, to address the most nefarious impacts of the socioeconomic crisis caused by the pandemic. Think of the purchase of vaccine, or even to the attempt to shift from oil and gas to address the aggression carried out by Russia against Ukraine. In other areas, something is happening. What about labor law? Now, we go back to consider the very notion and the foundational role of the social market economy, and we address it also from a constitutional perspective that is enshrined in Article 3 of the Treaty of the European Union. I apologize for the slide, but they are not centered, so I'm going to ask to our colleagues to basically offer the opportunity to everyone to see what is there. But if we consider the importance of this article, we should also try to understand whether the mandate is materializing in the real world. What is the notion of a social market economy? There is this compromise, moderate logic, the attempt of combining a very functioning and very competitive market together with social progress. The theory was developed by a German professor and politician who tried to design a model based on some kind of countervailing forces, some kind of powers that were aimed at tackling the failures of the market, the inefficiency of the market in the social field. This idea of harmony is kind of reflected in several instruments at the primary and secondary level at the European Union. There is a social re-equilibration mechanism that is about fixing and curbing the distortion of the market. This is the theory. This is what is mandated by the treaties, but we also try with Silvia and follow the evolutionary trajectory of this evolution and this attempt to constitutionalize the role of the social market economy. We are dealing with a competence conundrum, as all labor lawyers interested in European stuff are aware of, but we identify two main phases that we call the awakening of the social dimension because of the prevalence of a more market-oriented posture and approach, and I'm also sure that Silvia is going to focus on this, so I will try to stick with the time constraints, but we must take into account that the design of this polity started to crumble back in 1970s. It was difficult for member states to implement more progressive policies at the domestic level because this kind of quite protective employment protection legislation at the domestic level was read by the Court of Justice of the European Union, but broadly speaking by European initiatives, as an impediment to growth and as an impediment to the flourishing of a well-functioning single market. So the paradigm of upward convergence was somehow impacted by this kind of patchy interventionism at the European level. Social obligations, social policies were read as an economic factor, and there was a downward pressure, very explicit, to create a system where productive factors could flow very smoothly and easily. The idea was to build an economic entity disregarding somehow the importance of safeguarding labor rights. This is history. If the flexibility paradigm was something conceived where we were children, in a sense, we try to move from this to go beyond the status quo and to assess two very important initiatives, as I said at the outset of this presentation, the European Pillar of Social Rights, launched back in 2017, and the Action Plan, presented last year, so an instrument that was precisely conceived during the pandemic, amid the pandemic, and which is, in our analysis, very effective and explicit in setting some goals, some quantitative targets that are to be achieved at the European and domestic level. But then we find that despite the ambition, when it comes to concrete answers, something is missing. And there is a reiteration, new proposals, the new way of proposing the very same rhetoric that was developed within the narrative and system on flexicurity. Silvia is going to focus on the importance of the economic governance. We add a slight breeze of hope precisely because there is something new. All national plans of recovery and resilience are seen as the channel, the tool through which the principles and goals enshrined in the pillar are to be implemented. So we call for something different, something like a social conditionality that should be imposed on member states that are obtaining large amounts of money to fix the consequences of the pandemic. And we advocate for this precisely because there is momentum. The pillar is somehow flawed when it comes to concrete initiatives, but at the same time, there is a very important activism. If you focus on the 5 years going from 2016 up to today, several initiatives have been adopted, from a proposal of a directive on adequate minimum wages to a proposal on a topic that is close to me, such as platform work, some other instruments. They are, in a sense, very progressive on paper, but at the same time, and then skipping to conclusion, being under so authoritative pressure, there is something more. Some instruments are self-defeating, and I'm going to close with what we call a digital paradox. Now, as we may know, in the new proposal for a directive on improving working conditions of platform workers, there are some rules on algorithmic management that are precisely designed to tame algorithmic bosses by enshrining principles of transparency, accessibility, and also explanation. If we skip to another instrument that was mentioned before, the AI Act, here we have a problem from a constitutional perspective. We are witnessing, as we claim, a reiteration of something that happened back with the inglorious case law, such as Viking and Laval. Something similar is happening in the digital world. On the one side, a promotional intervention aiming at regulating algorithmic management. On the other side, a system that is based on risk and not on rights, which creates a ceiling rather than a floor. What we're witnessing, in a sense, is a digital version of Viking and Laval. But to say something more positive, I will conclude by claiming that when it comes to the next step, war is the key recipe. First one, we don't need more of the same. We should be addressing the non-binding legal nature of the instruments, such as the action plan and the European Pillar of Social Rights, which otherwise are condemned to become something like the 1999 and 2000 charters that have been elevated to the constitutional rank without being implemented in the real world. Then we also call for something that must be urgently addressed. While in the past the dichotomy was between the market and the social, what we underline is that the market today is wearing new clothes that are the digital ones, and this should be the key priority for a progressive European Union that is expected to develop what we call a convergence a la European, an attempt to combine the safeguard of legal rights with the promotion of a competitive and productive market. Thank you very much.
Thank you very much. Well, we all share your hope, and we'll see. Now, the next paper, again, is written by Silvia Rainone, this time together with Philippe Pochet. Philippe Pochet is also from the European Trade Union Institute and also linked to the Catholic University of Leuven. And this paper is very similar to what we just heard, because it's titled "In Search of the Social Dimension of the EU Recovery Strategy." And when you look in the paper, you see that it is mainly focusing on the action plan of the European Pillar of Social Rights. Go ahead, Silvia. You know, timekeeping.
Yeah. So thank you very much for the presentation, and I have to make a contextual remark. So at the European Trade Union Institute, we initiated a project on how the EU is approaching the recovery. And I'm part of that project, and this is why there was, let's say, two endeavors. One, the first that we did with Antonio, we developed throughout the past year, is quite normative regarding the Pillar of Social Rights. And then Philippe Pochet, who is actually the director of the Institute, he does not have a legal background, but is more social policy expert. He found very relevant to look at the more broader angle than the per se policy perspective, and looking at actually the fiscal and macroeconomic foundation of the European Union and how these actually impact on this, the social aspect of what Antonio has been presented till now. And the reason why we do that is that since the European Union has been moving towards becoming an European monetary union, we have seen that the focus is more and more on budgetary and fiscal sustainability and efficiency, budget control of the member state spending, and on macroeconomic imbalance, on avoiding macroeconomic imbalances. And this is as complicated, has put an extra layer of complexity to achieving the European paradigm of economic growth. So beside having competitiveness, productivity, there is also the need to pursue sustainable and efficient spending of public resources. And this has put the social and labor policy aspect under further pressure. So social labor policy aspects are more and more considered as variables, not only to competitiveness and productivity, but also to the fiscal policy framework. Whether we like this or no, depending on the normative approach we want to assume, but the repercussion of this approach were quite evident during the management of the 2011 crisis, when we saw that the public debt of the member state increased, and therefore the European Union established this architecture, this system of monitoring the public spending throughout a series of instruments like the six-pack, the two-pack, and among these was the European semester that was created. The European semester was dedicated to the monitoring of public spending and ensuring that the public spending would not impact on economic and monetary growth, integration. The repercussion was on the social and policy discretion of the national governments, and that were hit by this form of approach we can describe as austerity. So now, 11 years later, this framework, these mechanisms are still there. Nothing has formally changed, but we are approaching, and we are actually, the European Union is trying to approach the new crisis, but not so new now. But there is also, I guess, the shared perspective that the way the European Union is approaching the crisis now is way more solidaristic and social than what happened in the 2001 crisis. So the question that I'm trying to approach today is this solidaristic characterization justified? Can we actually describe why is that, and how can we make it last a bit longer? So what I'm being very briefly, I promise, going to touch today is what are the principal innovation of the recovery strategy, and then deepen a bit on the Next Generation EU because it's the biggest component, and then how these infrastructure impact on the economic governance, on the social, on the European semester, and finally concluding assessment. So the European recovery strategy can be defined as the European initiative to provide sufficient resources, so sufficient margin for public spending to national government to have the capacity to face the societal and economic challenge of the crisis. So this was, I guess, the first in a way also emotional reaction on this European institution toward the crisis. And this, there are a series of innovations that were put forward. The first was that the European institution decided to trigger the so-called escape clause of the Stability and Growth Pact. This means member states were allowed to to violate the margin of deficit and public spending. These allow an injection of public money into, businesses and social policies. And the Social Growth Pact was strengthened during the first crisis, so this is a remarkable difference. The second is a relaxation of state aid rules. During the 2001 crisis, state aid rules were allowed to be infringed only regarding the banking sector. Now instead we see a more flexible approach toward it. Then there was the SURE program, which is a fund of 100 billion euro that was financed by European debt. The European Commission was going to the financial market to finance SURE, that was then given to national government in the form of loans in order to give support, income support at the national level. Finally, the biggest component is the Next Generation EU. Next Generation EU took a lot of time to be negotiated. You may know better than me probably, is 750 billion. Is a huge fund that has been financed again by borrowing activity on the financial market by the European Commission, and can be accessed by the member state either through loans or grants. So the biggest component of the Next Generation EU is the Recovery and Resilience Facility. And this is the most interesting instrument to look at to understand whether we have a difference in the management with this crisis and the previous one. I'm just going to point out a couple of differences and innovation that make me actually support the fact that the Next Generation EU has a more solidaristic component. So first of all, for the creation of this 750 billion package, and specifically for the Recovery and the Resilience Fund, there was a creative interpretation of a legal basis that was considered impossible in the past or not politically viable. So the Next Generation EU is based on 122, which is an article that allows financial assistance in case of emergency under conditionality. So in this case, the Next Generation EU is of course triggered by an emergency, but does not only involve emergential policies, also there is digital innovation, green policy support, and these are not emergential, so there is, and especially there is no conditionality. So this is a innovative interpretation. Then it's also based on Article 175, which is about cohesion fund. But it's not only about cohesion. We see deepening of internal market and digital market. So it's a creative interpretation. And again, there is a possibility to infringe the no-bail rule, which says the European Union cannot save member states. And this is a very wide form of financial assistance. Then another innovative step is that there is a step towards debt mutualization. Why? Because the Next Generation EU is financed with a commission borrowing money on the financial market, and the most interesting aspect is that those pot of money that has been borrowed can be accessed not only in the form of loans, but also grants. So it means that in order for the commission to pay back the debt to the financial market, cannot exquisitely rely on the payback of the member state, because only the loan part will be paid back. For the grant part, the debt is actually mutualized. And this is a very strong innovation. In order to maintain the equilibrium in the spending, the innovation was that the member state agree to higher the ceiling of possible contribution than between here 2058, they may be required to give back to the Commission. So there is this. Then the Next Generation EU consists de facto in a promotion of investment. So it is an injection of money in specific area. Digitalization and green transition especially, and this is quite a novelty. A second set of innovation is that, differently from the previous crisis, the financial assistance can be assessed without conditionality. For the conditionality means that the member state that access the fund do not have to promise to undertake any structural reform to adjust the public spending and lower the debt. This, in the past, has given the step to a form of austerity. This is not the case now. Indeed, the moral hazard narrative of the frugal country was able to be marginalized in the conversation and in negotiation. The only form of conditionality, quite interesting, is the respect of the rule of law. And this is also connected to the fact that rule of law is very important to avoid corruption, to avoid fraud, and therefore is good for avoiding increase of debt or bad management of this financial assistance. Again, another novelty is that the European semester that originally was set up to ensure good public spending, this time is going to have a new role. Indeed, is going to use the European semester to ensure that the investment are channeled in the way that the member state promised. So it's a new use of this institutionalized system. Finally, there is, as Antonio very well explained, there is a social dimension. There is a European pillar of social rights, which is integrated. So the member state, to access the money, need to explain how they're going to implement the pillar. I'm going to skip on this part and just go on the assessment of it. So I believe that there is a justification in the perception that it is a more solidaristic approach to a huge economic and social crisis. There is a more human-centered approach, as the topic of this conference rightly pointed. There is a solidaristic rationale, and there is a social awareness. However, and this is more the content I take from Philippe Pochet, let's point at the reason. Why is that? Well, there is a change of actors. In the management of the previous crisis, the focus was more on, well, there were a lot of political actors coming from the conservative family. Even at the European Commission, it was the Barroso Commission. Now the von der Leyen Commission, the president is from the same family, but we have a representative from S&D coming from, the Commissioner for Economic Affairs and for Social Affairs are from the more leftist family. Then there is a shift in ideology connected to the shift of actors. There is less scope for moral hazard and more space for public health concern. But these are weak foundations. And I connect back to the conclusion of Antonio, because if the political actors change, well, all this is destined to maybe to disappear and to regress. So how do we avoid the regression? We need to reform economic governance framework. These need to be reformed to avoid those rules, to make sure the escape clause of the Stability and Growth Pact is maybe not forever triggered, but the targets are adjusted. We need social conditionality, as Antonio mentioned. And there is a scope for treaty revision, and this is the last phrase, because as a result of the conference on the future of Europe, this democratic exercise provides a list of possible amendment to the treaty, and it seems the European Parliament is now taking them in consideration. And there are also changes on the social policy chapter, so this can be a promising avenue. So this is it. Thank you.
Well,
and thank you, Manfred. I'm sorry.
I apologize to all the speakers for my pressure, but I have no alternative, you know.
Sorry
well,
for
the next speaker will be Montserrat Sole Truyols. Am I saying this correctly? Well, we heard already now from Silvia about the Recovery and Resilience Facility, and our speaker now will ask in how far this entity will help to improve the quality of employment from a perspective of labor conditions. Am I right? Okay.
You are correct.
Go ahead.
Okay, thank you very much, Professor Weiss. Thank you also to the Marco Biagi Foundation for accepting this paper. So if I know...
Well, I can't help.
Okay.
But there's the gentleman who can help. I asked him.
Where is my presentation?
What's the title of the PDF? What's the title of the slide?
Employment of quality.
He's already trying. You see, we lose time with this new technology.
Otherwise, I have my pen, if I can put it somewhere.
I have the feeling PowerPoint is a regression, you know. Beg your pardon? Yeah. Yeah. What is happening? Well, we have at least, you know, understood by the last two papers that different from the phase before, when the neoliberal approach was prevailing, social policy is no longer a sort of mere residual category, but is now something which has a right of its own. Now you have it.
Okay, thank you. So I follow a little bit of what Silvia and Antonio have already talked, but I will center on the working conditions. The question is employment of quality in the Recovery and Resilience Facility. Is that right? And why? The Recovery and Resilience Facility is the biggest package within the Next Generation Funds, and the quality of employment is something which is not new at UA level. Principle 5 of the pillar already talks about that. the employment guidelines also, the European Pillar of Social Rights Action Plan as well, and lastly, and the more recent, the Porto Declaration. And here in the Porto Declaration, it says clearly that the quality of the employment will be secured by implementing the European Pillar of Social Rights principle. Then those are political documents, but the Article 4 of the Recovery and Resilience Facility, which is a legal instrument, says clearly that the objective of the facility is the social and territorial cohesion of the European Union, and it will contribute to that cohesion the creation of quality of employment. Let's see if that may be the case. There is a quality of employment framework at the European level. The UNESE dimensions, which are 7, I put only 6 because the last one does not affect working conditions. Those 6 dimensions, if you look at it, they are also translated into the Eurostat quality database with some appropriate indicators, and as well, these convey the principles of Charter 2 in the working conditions. So we have a consistent, at European level, we have a consistent framework to measure the quality of employment. What happens? The Recovery and Resilience Facility is a complicated instrument because of its far-reaching objective. In short, it's a financial document, but it's also a socio-economic document. The National Recovery and Resilience Plans, which must prepare every state, link these 2 functions, and they must express, the National Recovery and Resilience Plans must express their contribution to implementing the pillar principles and their contribution to job creation. Here, everything is perfect and everything is consistent. However, the national plans will be assessed by the Commission on the social scoreboard. They will be assessed on how they implement the pillar principles, but how the implementation of the principles will be measured against the social scoreboard. What happens with the social scoreboard? Look at this, please. They do not talking about working conditions and the quality of employment, which is my focus. Employment rates and unemployment rates, or long-term unemployment rates, do not say anything about the quality of employment. They say about the quantity, but not about the quality. Furthermore, and that's the other problem, if we are saying that the national recovery and resilience plans must implement the principles, there are many principles of the working conditions, such as the information of employees or the social dialogue, which are not represented in the social scoreboard, not at all. So, as a first conclusion, there are no incentive for member states to use the funds, to use the recovery and resilience funds to improve working conditions. If we then go to the European semester, which is, as Silvia has already explained, I will skip that. But the European semester introduces the European Pillar of Social Rights principles as well as the action plan. What happens here with working conditions strictly focused? Yes, the national and recovery plans will be assessed not with the social scoreboard now, but with the action plan. Again, if we look at the action plan, nothing about the quality of working conditions, just quantity. I look also at the proposal for a joint employment report, which is now a proposal and will be probably accepted. The joint employment report sets the areas of improvement. If we look at that, we see that no social scoreboard is used by European Eurostat indicators, but no suggestions on how to improve the working conditions. The role of social partners is very, very limited in the Recovery and Resilience Facility and as well in the Joint Employment Report. And all that leads me to conclude with two special things. The first, no employment of quality can be expected from the Recovery and Resilience Funds. Accordingly, the overarching target may be compromised, but most important is that perhaps what we need at the European level is to adapt the social scoreboard. I do not say that it is not needed, it's needed, but as far as working conditions are involved, we need a social scoreboard that reflects all the working conditions that are in the principles and in the quality of framework.
Thank you very much.
Thank you.
Well, until the... Isabella is already here. But just let me say one thing. You know, I agree with you in this facility. There is nothing explicitly on the quality of working conditions. But we have to see that the European Pillar of Social Rights, as well as the action plan, is making reference to the fundamental social rights of the Charter. And the question, of course, is if you look to that, where it says there have to be working conditions in line with human rights, you know, whether this is not something which, similar to what the ILO does with the decent work, might lead to a sort of quality of working conditions. Only a question. We will discuss about this. Okay. Isabella, wonderful that you are with us. Do you hear me?
Yes, I hear you. And do you hear me?
Yeah, we hear you. Isabella Florczak is coming from the University of Łódź in Poland, and she has a very interesting question. She says, still private or more public? And what she means, she says, did the pandemic change the scope of labor law, making it more public? And of course, her assumption is that before it was more private. I would doubt that. Well, we will see. Go ahead. Go ahead. You have only,
Thank you.
I'm sorry to say, you have only 10 minutes because we have no choice. Okay?
Okay. I will try to be according to the time frame. So thank you very much for accepting my paper, and I'm really very sorry not being there with you in Modena. So the research question of my paper basically is, has the pandemic resulted in a sustained increase in the burden of public law obligations on employer arising from the legislation? Or maybe all the obligations connected with the COVID-19 are simply the part of an obligation to provide health and safety conditions at work. And even if so, the question is, I will have a lot of questions today. The question is whether the obligation to provide health and safety conditions at work is also, or it is as such, a kind of a public obligation. And what I would like to tell you is that in Poland, there is a huge discussion caused by one of the professor and then sustained by one more, whether the labor law belongs to private or public law. And those two professors claim that right now, we can claim that labor law is a part of a public law, not part of a private law. But to answer this question or whether to start a discussion about it, of course, we have to determine what is the public law and what is the private law. According to the theory of a subject, distinction between private and public law is related to the question whether one of the parties to the relationship has the authorization of the state authority. If one of the parties of the relationship has such an authorization, then the relation belongs to the public law. If not, the relation belongs to the private law. And here another question arises. What is this authorization? It's also an order to act in a particular manner, such kind of an authorization made by a state. Right now, it has been rather accepted by the law doctrine that the labor law is a private law. The employment relationship remains a relation between employer and employer, regulated, of course, within the limits of the applicable norms according to the law. This does not, however, means that elements of public law are not recognized in the labor law, in particular, as I already mentioned, when it comes to obligation of employers. And these obligations are mainly related to the social sphere of employment. So then another question arises. As I said, I will have a lot of questions today, not necessarily all of the answers. Is it so that when an employer bears the cost of employment, which is directly not related to the labor equivalent, such an employer performs part of the task of a public law nature imposed by the law, for example, when paying for a sick leave? And according to this question, another one arises. What are the reasons why some social relations, like the relation between employer and employee, create a part of a public domain, are put in the course of a public domain? And has the COVID pandemic changed the scope of this obligation when it comes to employment relationship? Maybe, and this is what I'm pretty sure of, it is because employers play a very special role in the society. So in the next part of my presentation, I would like to relate to the concept according to which a workplace is or can be recognized as a part of the society. Nowadays, work environment is often the only or usually the main social environment in which modern people function, especially in the developed countries. I'm even tempted to compare modern workplaces to kind of tribal societies, where the center of life interest is concentrated within a specific structure. I don't know if you are aware of the fact that on average, people spend without any break, approximately 13 years and 2 months at work. It means that it is like if we add all the time when we work, it is 13 years and 2 months. This is though reasonable to conclude that due to the time frame people spend at work, working environment can make a huge impact on the quality of life. That could have been observed during the time of pandemic, because if it wasn't the case, why do we need remote work at all? So the COVID pandemic has resulted in an increase in actual participation of employers in public policy tasks worldwide. Many public health responsibilities, such as providing protective measures or even enforcing vaccinations, have been or still are imposed on employers. It seems that even representatives of employees and employers somehow understand this role of a workplace as a social place. And for example, in Poland, where the social dialogue is in terrible shape, sometimes it can be even claimed that it does not exist at all. At the beginning of this year, a real miracle happened. All the influential unions and employers' organizations signed an appeal to the Polish authorities to make anti-COVID vaccination mandatory. This is something what never ever happened before. It was noticed already in the pre-pandemic era that employers are an indispensable and vitally important, that they play a vitally important part of the functioning of society. And their role is not simply that of provider of work and remunerator of work which has been done. During the pandemic, employers were recognized as very important part in the public health assurance chain. It was manifested, for example, by imposing on employers an obligation to verify the fact of anti-COVID vaccination. From this perspective, it is of course important to determine the scope of this obligation. So the important fact is whether the employer can impose sanctions on worker for not being vaccinated, can the sanctions be imposed on employer for giving an admission to work to non-vaccinated workers. Different models of vaccination policy, such as the one of which was already today presented, one in Italy, or Austrian model of 3G, where or still are part of our situation right now. What is important in the model in which an employer has an obligation to verify the fact of vaccination is to give to the employer a legitimated tool to perform this obligation. Also, what is very important is that in the time of pandemic, many employers undertook additional, totally voluntary social activities to that benefited their workers. Among these measures taken by employers to increase the vaccination rate, because that was the aim, there were such an action like organizing vaccination campaigns, or even allocating additional financial resources to financially support those employees who were vaccinated, so we can call it vaccination bonus or vaccination benefit. And this latter action has become a subject in Poland because it was a case that some employers were paying additional money to people who were vaccinated. And the Polish National Labor Inspectorate did not question this campaign of payment of such bonuses, but of course it can be considered in terms of indirect discrimination, because as we know, not everyone could have been vaccinated. And to conclude, in many cases, the obligation imposed on employers during the pandemic are or were linked to the public duty, a duty to ensure the protection of public health. In my view, employers are the natural recipient of this duty because of the social role they play at the work environment in the modern world. Because of this role, employers are increasingly becoming the recipients of responsibilities that are crucial to society and even of critical global importance. And here I'm thinking primarily about what we can call the climate challenge. However, in my opinion, these trends do not seem to be an endorsement of the public nature of labor law. Rather, they are an evidence that employers, or maybe better say workplaces, or maybe even better to call it work environment, are the essential part at the society. Thank you very much.
Thank you very much, Isabella, for this very, very clear presentation. I just would remind all of us to perhaps look to what Hugo Sinsheimer, one of the founders of labor law, has written. For him, the divide between public and private law was considered to be irrelevant, because he would say labor law is an entity sui generis, you know, and therefore I'm asking myself whether, well, it makes too much sense, Isabella, to put labor law in one of the two boxes, you know, but we will discuss this. Now, before we discuss, we will hear the discussant of this session. This is Massimiliano Delfino from the University of Naples, and you have also 10 minutes, okay?
Yes, thank you. I don't know if the microphone, I think it doesn't work.
Oh, I go to... Technology.
Okay. Thank you for inviting me. Thank you, Professor Weiss. The papers were very, very interesting, and also all the presentations were very interesting. It's difficult when you have different papers to be the discussant of those papers. So I decided to focus on 3 or 4 issues, main issues, which have been dealt by the authors of the papers. I think in the background, as everyone knows, there is the problem of health protection, health emergency, which is very evident if you look at some of the provisions, some of the measures that the European Union has taken during the COVID-19 pandemic, such as the suspension of the freedom of movement, which is very peculiar, and maybe it is the first time that has been the freedom of movement has been suspended, and also another one which Silvia Rainone has already addressed, has already underlined, which is the tempering of the rigor in the matters of state aid, which is very peculiar as well. There are many others, but I think this one are the major ones. The second issue, which is common in almost all the papers, is the issue of public intervention or public investment in the double sense. That issue has been dealt with by Juan-Pablo Landa when he says that all around the world the state is back, maybe the state is back, and maybe that it is reaffirmed the leading role of the nation states. And also by Antonio Aloisi and Silvia Rainone. I consider all the papers of you as one paper, since there is a lot of circularity in both of them. Antonio and Silvia reminded us that national legislator should provide a system of social and welfare guarantees in order to counterbalance the transformation that economic liberalization entails. And also Silvia Rainone, again, the other paper, she addressed the importance of public spending, so the public, in another sense, the public intervention in another sense. And as we have already heard, Isabella Florzak underlined the importance of the public intervention in another sense, the public dealing with the public nature of labor law. I agree, but this is not new. For instance, for not this distinction between public and private, I agree with Professor Weiss, is quite useless in a sense, but it is quite common an intervention by the state in some of the member states. I would like to say that even though there was an intervention by the state, I think never has changed. There's no change in the mutual obligation of labor law. I think it is quite common that some of the member states, of the European Union member states, provide an intervention by the state, by the legislator, or by public funding. The other issue is the issue of the changing approach of the European Union in comparison with the financial economic crisis of 2008 and so on. This issue has been underlined by Juan-Pablo Landa again, when he indicates that COVID-19 was not a revolution, but a correction, maybe could be the cause of a correction of the functioning of our productive economic model, but without replacing it, and also again by Antonio and Silvia, and I think this is a very important topic. The topic of the action plan of the pillar of social rights and the action plan in order to implement that pillar of social rights. And this is a change of attitude in respect to the previous intervention during the economic crisis. If everyone reminds that during the economic crisis, the European Union intervened a lot in order to cut off, for instance, salaries and pays, and so the approach here is very different. But I would like to say that it is necessary to be careful. In which sense? To be careful because of you stress the importance of the pillar of social rights, but as Professor Weiss has already told us, I think you should concentrate more the attention on the Charter of Fundamental Rights. And so that's the reason why I do not totally agree with the suggestion contained in your paper, which is a suggestion according to which the European Pillar of Social Rights could be invoked before the Court of Justice. I don't think it will happen. I don't think it will happen, since, as everyone knows, there is the case law of the Court of Justice on the Charter of Fundamental Rights, and the interpretation of the Court of Justice is quite restrictive as regards the role of the member states, while it is not so restrictive when it refers to the European institution. So it could be a good idea to intertwine your consideration about European Pillar of Social Rights and the Charter of Fundamental Rights that can be easily applied by the European institutions. And the last issue is the role of the social partners. I know that there is another session about the role of social partners, but most all of the authors of the papers have underlined the role of social partners. First of all, again, Juan-Pablo Landa has underlined that it is necessary to entrust collective bargaining to design the internal flexibility measures to each company or economic sector. Or, and Antonio Aloisi and Silvia Rainone again, when they, and also Montse Truyols, both of them, they underline the lack in the action plan of a great space to the social dialogue, information, consultation, and so on. But I think that, and especially Montse Truyols has underlined that the presence of the social partners, of the role of the social partners is very limited in the European Pillar of Social Rights. I think the problem of the social partners is very important. Yes, I'm finishing. Okay. The role of social partners is very important, but again, you should take into consideration the Court of Justice. As everyone knows, also in this case, the Court of Justice ruled, the European tribunals ruled twice on the so-called horizontal subsidiarity. And those judgments are very important in order to consider the new role that the European social partners can have in the future of the European Union. As everyone knows, the role of the social partners seemed to be reduced after the EPSU judgments. I'm referring to the EPSU judgments. But maybe the EPSU judgments could also be a way to restore the role of social partner, maybe of an autonomous social dialogue, more than an invoked social dialogue, according to Article 154 and 55, Articles 154 and 55 of the Treaty on the Functioning of the European Union. Okay, thank you. Thank you very much for your attention.
Thank you very much, Massimiliano. I'm thrilled, you know, by the discipline of the speakers and of the discussant. It's just wonderful, you know. Things are getting better in the world. Well, I would like to open now the floor for the audience. We have, because we have started 5 minutes later, one moment, we have started 5 minutes later, so we end 3:05, which means we have now 20 minutes, and I'll do as we did already this morning. I take the different interventions, and please be so kind and let us know whom are you addressing with your question. Then it might be easier for the respondents afterwards. So, Rüdiger, you start.
Yes, thank you very much. I'm also thrilled on the inspiring presentations and also what Massimiliano has said in this discussion contribution. Massimiliano said the state is back, and for a labor lawyer this is not the worst message, and as regards the European Union, okay, it's not the state, but the public power is back. But on the other hand, and I will primarily, I think I address Silvia, when I hear as a labor lawyer that labor law is more or less, or could be subsumed under fiscal policy, that's a frightening perspective. My question is, and it's a double question, are there any attempts to challenge this tendency, this policy tendency with legal arguments? Because we have heard there is a Charter of Fundamental Rights, the European Court of Justice is an actor, and an important actor, are there attempts to build some kind of argumentation on a legal basis? The second might be a bit contradictory to that. There is a saying, of course, you know it, if you can't beat them, join them. That means, are there any attempts, on the other hand, of the, let's say, social partners, trade union movement, to step into the fiscal policy and to say, okay, we could use it for particular purposes? It might be a dangerous strategy because it's contradictory to the first one to say, okay, labor law is a point on its own. But, okay, sometimes you need two strategies.
Please try to not give a paper, but to just ask a question.
Okay. Barbara Sołdykowska, Polish Trade Union Solidarność. I will try to be really brief. This is a comment for Silvia. I don't want to start the discussion, is the glass half full or half empty? But from the beginning, in the recovery and resistance plans, there was a direct money for greening percentage and for digital transformation. There was no percentage for the implementation of European Pillar of Social Rights. So I think that from the beginning, the architecture was not so friendly to the social issue as at least I understand you presented. And other issue, I think it's crucial to really look through the recovery plans, because in many cases, I haven't, of course, read 27 of them, but at least in the Polish case, this implementation of European Pillar of Social Rights is just 2 paragraphs of very weak rhetoric description of these goals. And in the other recovery plans, which I so more or less look through, it's also very soft implementation. I wouldn't call it really implementation. So I think you are a little bit too optimistic in this whole picture. Thank you.
Yes, please. Here. Mikey, tell us.
Yeah, Mecca Howard, sorry. Yeah, I'll try to be brief. I want to bring in perhaps a more optimistic
Perhaps
example.
a bit louder. I don't know whether those
hear me?
in the rear
Okay.
understand.
I'll do it like this. So actually this question is to Montse and partly also to Antonio and Silvia, but then you have seen it more high over, whereas you have more looked concretely to the RFF. So in our paper, which was written also by co-authored by a Spanish author actually, there is an example, and I was wondering whether you also note that example in your paper and or whether there are more examples. So apparently the recent reform in Spain of fixed-term work was as a direct consequence of this recovery and resilience fund. So I think that is actually a sign that there is some impact regarding job quality, but I'm curious for your remarks, and also whether more broadly, and perhaps I hope at least, as a counter argument regarding the worrying signals of what Barbara just said, do you see more positive notes? I would hope so. Thanks.
Further questions? After such inspiring papers. My site is not good enough. I haven't seen it.
Thank you very much. I have a question for all speakers here.
Louder.
Since you're trying to take an approach from higher, I wondered if you had thought of digital constitutionalism and whether you could say a word about it. Thank you.
Further questions? Yeah. Mike, you want again? Yeah. Okay.
Thank you. You mentioned, Isabella, a very interesting example. What you said, there's a kind of social pact, if I may translate like that. For the first time perhaps between social partners in Poland who try to press together from a joint opinion, the government. Is this a kind of thing that you see future for, like what we used to say about, at least in Western Nordic European traditions, that there will be a kind of bargaining in the shadow of the law? In other words, that there must be something in the law which is too strict for employers, so to give them an incentive to join forces with the trade union. I'm curious for your point of view.
Thank you. Somebody else? I have problems in seeing. Well, if not, I give the floor to, Silvia starts.
Yeah, I will be super brief, and thank you for the good questions. So first, Rudiger, about the legal and juridical safeguard, if I well understood, whether we can think about that. And actually, I think that the response may be, well, in the treaty already, there is the constitutionalization of the Charter of Fundamental Rights, and if that will be invoked and considered better by the European institution, I think the balance will be more focused on the social aspect of it. There is no right to good fiscal budget, but there is right to, I don't know, like a minimum decent standard of living. So that's, I think the answer is more in the political will. And it would be interesting, for instance, if a treaty revision will ever happen, to introduce in the policy, in the treaty chapter on economic governance, social safeguard with respect, not as much on the pillar, on the social pillar, because I believe it's a bit ambiguous instrument, but on the charter itself. I really take on board the suggestion of Massimiliano on that. And then on the perhaps too positive approach, and I think it's definitely possible to see a too positive note on the presentation. I share totally. I also analyze a bit a couple of national resilience plan, and sometimes, well, they have to have a page where they say how they will implement. Sometimes we're just like nothing there. And all the time the Commission judged it as A, graded as A, like, yeah, sure, they do. So I fully agree that the assessment of the Commission has been formal, it was a political negotiation, but it's interesting to look at the country-specific recommendations, so the final output of the semester process this year. And it's quite interesting because, as Michael also suggested, there are a couple of instances in regard to the Netherlands and Sweden where the European Commission recommended national government to curb precarization in the labor market, to put a limit to the renovability of fixed-term work. So this is a total game changer. I'm not sure it's because, what is the reason, but it's definitely different. Something that came back is pension reform. The accent is again on pension reform. So this is a bit scary, but yeah, so there is some change. And perhaps...
Isabella, there was a direct question to you. I come back to you, Antonio. Isabella?
Yes, I'm here. Yeah, so first of all, when it comes to this distinction between private and public law, I totally agree with what was said that maybe it is even pointless to start the discussion because labor law has a very, very special structure between those two. And that is why during my conclusion, I tried to emphasize that what is right now very important is from the perspective of a worldwide policy, as such, taking into account the work environment, which I understand very, very broadly. Also, when it comes to the representation of employers and employees. And what happened in Poland and what was the question about was about this miracle that it was the first time when the unions and the representation of employers gather themselves and prepare a statement together. I would not be optimistic and I would not assume that such situation can happen in the future. It is quite in a Polish nature that when there is a crisis, we do gather and we can act together. But then, when the critical situation is over, we become to fight again. So it was the first time ever when something like this happened. But I do not assume that it can happen in the future again, if any other dramatic situation will not happen. So I think that right now what we still do need when it comes to the social dialogue and the action of social partners is the more from the side of legislation than the action of social partners as such. I hope that I understood the question correctly and that I answered it.
Thank you. Well, Montserrat?
Yeah. Do you hear?
Loud.
Do you hear me? Oh. In reply to, do you hear me now? No? Well, I will try to speak louder. In reply to Mike, yes, you are right. The reform of the Spanish temporary labor market was a precondition before getting access to the funds. It was a precondition. Why? Because the Spanish temporary rate was, I think it's the most higher in the EU by difference. And it has changed. That's true, but it's more on my opinion, it's more an statistical reform than a working condition reform. We will see. This is an opinion, and we will see what happens. But you know, now you are not in a temporary employment, but in a open-ended contract. But you can be in and out the labor market according to the employer's needs. So now you have social protection, but I'm not sure. But I will make it clear. It's not an implementation of the European Pillar of Social Rights. It's a previous precondition to get access to them.
Okay.
I'm
Antonio.
Brief, just to build a bit on the Spanish perspective, it is true that first it was a precondition. Second, it is a counter-reform, in a sense, to address the most problematic features of a previous reform. Second, when it comes to the cosmetic improvements, I also agree with the fact that the introduction of this new intermittent contract provides for the existence of an employment relationship that is open-ended, but it is something in line with the fire and rehire model that we know from the UK. At the same time, if the substance does include some kind of improvements, for instance, the stable contract of employment, the standard employment is identified as the prevailing form, and there is the introduction of some kind of clauses and justification for the adoption of fixed-term contracts, what is probably very promising in terms of implementation of these measures is the method by means of tripartitism, in a sense. And this is also connected with something else that has been said today. Political willingness is key. In that case, the Ministry of Labour has been able to mobilize social partners to get also the approval by the representative of businesses and small and medium enterprises. So the substance is somehow bittersweet, but the method is very promising, and it has been adopted several other times when it comes, for instance, to minimum wages, to the adoption of the very commented lay rider, and so on and so forth. So it is a revival of the social forces, at least at the domestic level in Spain. And a word to the point raised by Claire on the emergence of the very notion of digital constitutionalism. I think that the premises are a bit weak, because claiming that we need a new age of digital constitutionalism partially subscribes to the idea that the digital is a compartmentalized dimension of the labor market and in general our society. The digital must be embedded in all the existing rules, but this is what several lawyers and experts that are calling for digital constitutionalism at the end are trying to advocate for. So while the outcomes of the theory are very important and ambitious, I'm afraid that claiming that we need digital constitutionalism brings us to believe that the digital world is operating in a void, something not interconnected with our society. And to conclude on this, the measures that are invoked on the basis of this notion of digital constitutionalism are a bit reactive instead of anticipatory. And this is quite problematic when it comes to technology. We've been discussing this so far as regarding several instruments, including the AI Act. Probably we should shift the narrative, moving from an ex-post damage control approach that is also based on constitutional remedies to something that is anticipatory, participatory, and that is preemptive instead of reactive. And I'm going to stop here because I'm...
Thank you very much, Antonio. Unfortunately, Pablo Landa is disconnected, but let me say one thing. After this splendid discussion we had, I think we had so many viewpoints. In my long life, you know, I have worked for social policy in the European Union for many decades. We had situations where we were desperate, where we thought that there is no more way for social policy at all. I remember the year 1979 when Maggie Thatcher entered the scene. You know, this looked like the end of everything. Well, then we had, you know, the phase of the Lisbon agenda and of the Agenda 2020, where only this macroeconomic governance counted, and the goal was only economic efficiency and nothing else. And labor law, social policy was a residual category and nothing else. And at least, and this is something, you know, we should build on, it has changed. And I think the European Pillar on Social Rights, including the action plan, should not be underestimated. Of course, it's only a sort of program. It is not legally binding, but it is a change of paradigm compared to what we had before, you know. And there we can build up. And, well, I would say we should try what we can, you know, to link this European Pillar on Social Rights with what we have already in the Charter of Fundamental Rights. And it's our task to make sure that this will be the point of orientation and nothing else, and then it might work. Well, let me thank all the speakers. This was a wonderful session, and I see that we are in time, and now we have, I think, 5 minutes break until the next session.